Okay, so now let's move on to the big H-1B. Unfortunately, the H-1B is generally subject to an annual cap. And the government's made it a little bit complicated. So the H-1B has been oversubscribed. Now, if you're a cap exempt institution, which is a university basically, or research institution affiliated with the university, then you don't have this cap problem. So that presents a little bit of a challenge because they only issue 85,000 H's a year. The H visa is approvable initially for a period of 3 years and is renewable for an aggregate period not to exceed 6 years unless there are certain circumstances. Now, I spoke about candidate assessment. So when hiring foreign nationals out of school, fine. You know, if you got them on OPT and STEM OPT 3 years, you get 3 shots at the H-1B. And I would encourage employers not to leave it to the 3rd year. The reason is that the statistic on selection varies. It was bad last year. I think there were a lot of duplicate filings. It's been as high as like 43%, but we don't have the final statistic for last year, but it was bad. It was under a third was selected, so ouch. On the positive side, if you're working with an H-1B, they have a new registration process that I'm going to go through. The fee is $10. So it's not exactly a backbreaker. So I do encourage you to put your F1 OPT folks into the H-1B through this pre-registration process. And the registration submission was in March this year. I'm going to assume it's going to be in March next year. So please put in your calendars March 1. If you have a lawyer, they should contact you. If you don't have a lawyer, contact me or whoever else you wish to work with, of course. I do encourage people to work with, if you're in California, a board-certified immigration specialist. We are a subspecialty area. You're moderately safe if you work with a board-certified specialist. I think one of the problems with immigration, and I like calling myself an ethnic too, although I'm a naturalized U.S. citizen, but, you know, a lot of ethnic lawyers get into it. There are some immigration lawyers who aren't quite up to scratch. This is complicated stuff. It's got to be done right. You know, I think a lot of people are uncomfortable sponsoring because they haven't had the opportunity to work with somebody who gives clear black and white answers. I like to be that person. I don't mind saying no, but I don't like leading people along. I don't want to file a case unless it's approvable. And in order to be approvable for an H-1B, you do have to pay a prevailing wage. You can't pay the minimum wage, unless, of course, minimum wage is the prevailing wage. So you are going to be paying pretty much a market wage. You can't hire people on an H-1B at a lower salary than U.S. workers. That's not permissible. It has to be a similarly situated wage. But the good news is that you don't have to file and then not get selected in the lottery. You can just do this registration thing. And there's the timeline. And then if you're selected, you have this 90-day period to file. And then the H-1B starts in October. There's something called premium processing. I actually call it highway robbery. The government charges you extra $2,500 to do their job properly. But that way they give you a 15-day calendar decision. One of the problems with immigration is they are kind of overworked and backlogged. It's an agency which I don't like to say negative things because there's a lot of people who try very hard to do their job right, but they tend to be overwhelmed. And cases tend to get backlogged and things tend to be slow. So they have this thing called premium processing where if you pay them an additional $2,500, they will give you a decision within 15 calendar days. It's a lot of money. And I generally discourage people from paying it. So, yeah. Okay, so I already mentioned this. As I say, I don't really follow the slides very carefully, but that link there to FLC data center is kind of important, because you as an employer can go online and check out what the prevailing wage is. And you may say to yourself, well, no, you know what? I'm not ready to pay that wage. But that is the wage that you're going to pay unless you have your own wage surveys, in which case you can show the government that your wage is a prevailing wage. They want to protect the US workforce. They don't want you to use the H-1B to import cheap labor. And yeah, so you have to do this filing with the Department of Labor. It's not complicated, but you've got to do it right. Notify, you put up a posting notice, or we actually do it electronically through our system, where we post the job position. And that is one of the requirements for the H-1B. So Eddie, moving on to employer obligations for the H-1B. What is the downside? Well, the employer does have to pay the government filing fees and the legal fees for the H-1B. So don't make the foreign worker pay. Also, if you terminate that foreign national prior to the end of the 3-year period, you do have to offer to pay the reasonable cost of transportation back home, one-way airline ticket. They don't want the foreign national stuck here. So that's probably the biggest burden. The truth is, you're going to find most of these foreign nationals are not going to go home, even if you lay them off. So you don't have to pay the airline ticket, but you do have to offer. And I have to encourage people who are not familiar with the process, you must, repeat, must withdraw the petition after the foreign worker leaves. Otherwise, you could be on the hook for the salary. So this is with the Department of Labor. So, you know, we look after our clients. We make sure you follow the rules. Yes, there are rules. Yes, the Department of Labor is a tough agency. You don't want to mess with them. We play by their rules. We don't want to be the tough guys. But, you know, if you comply, then there's really no issue. But if you think, oh, well, I'm going to import cheap labor on the H-1B program and I'm just going to like do spec work and things like that, it can be somewhat of a challenge. So we make sure that our clients are compliant in every sense of the word. Addie, next slide.
There was a question related to this topic. What if the employee resigns as opposed to gets terminated? Yeah.
I have to double check, but my understanding is you still have to pay the reasonable cost of return transportation. I have to double check that. I don't know why I don't have the answer on the tip of my tongue, but the whole issue is they don't want, this is the Circus du Soleil provision. Sorry, I've been around long enough, but, and it wasn't the Circus du Soleil, but one of the circuses went broke when they were traveling in the US in 1990 when they did the law. So they added this provision that you have to pay return. They didn't want these folks stuck in the country. So, but again, you know, at the end of the day, a one-way return airline ticket to even the farthest destination, Australia, you know, what is it? It's $1,000 probably. I mean, it's pretty steep, but yeah, that's the biggest obligation you have. My thing is, if the foreign national leaves prior to the designated, I think I actually have to look that up. I'm a little embarrassed. There's a decent chance you don't have to pay return transportation if they leave voluntarily. It's generally when you terminate prior to the designated period, but I'd have to look that up. I'm a little embarrassed. Moving on, Addie. So some of the myths associated with H-1Bs is that small companies and startups cannot sponsor. the truth is it's a little bit more difficult. So like if you have two employees and you say, well, one is a financial analyst, the government really wants to see that that person is a financial analyst and not an admin assistant. They want to see that the position is what we say it is. So, you know, you can't just put a label on it. For the H-1B, you do not have to show unavailability of U.S. workers. That's a very important one. For the H-2B, the temporary worker one, yes, you do. But for the H-1B, the whole idea is that you're bringing in this well-qualified USC graduate, and there's no requirement to show unavailability of U.S. workers. It's a temporary work visa. The position does not have to be full-time, but don't go under 20 hours a week. You do not have to have a master's degree at the time you file, but if you do have a master's degree, so there's actually two lotteries. There's the H-1B lottery of 65,000, and there is the master's degree lottery, which is an additional 20,000. I spoke briefly about the premium processing. This is the expedite. It does not increase. It's not like you got a better chance of being selected. So again, I discourage employers from wasting money. And in many instances, that is a waste of money, but there are a few cases, for example, where you've left the OPT to the third period, the OPT is expiring, and the H-1B hasn't been approved. There are situations where I will have to recommend premium processing because we've left it to the last minute. But if you plan ahead, generally, you won't need to use that. This point number 8, that you must work for a certain period of time on an H-1B before green card sponsorship. Some people think, oh, well, you know, I have to be here for 2 or 3 years before I can sponsor them for the green card. Not true. Not true. Actually, one of the interesting things that we've spoken about is that technically you could sponsor them for a green card while they are on OPT and jump straight from OPT to the green card. Not all employers are enthusiastic about that option, but it avoids the need for even getting an H-1B. So we have been doing that in many instances, particularly in shortage occupations, where the employer wants to be enthusiastic and generous in terms of looking after its international student or foreign national population. So, Eddie, let's move to the next slide. We're talking about H-1B alternatives. Oh, this comes up every year. So